Good afternoon, my lady. Can you see and hear me?
I can, thank you.
I think we're ready now to go to Mr. Westgate, King's Counsel, who will address you on behalf of Shelter.
Mr. Westgate.
Thank you. I hope you can hear me.
I can.
Thank you. I act on behalf of Shelter, a charity working across the fields of housing and homelessness, providing legal help and services, and also acting as a campaigning and research organisation engaging with national and local government. Shelter's grateful to be designated as a core participant, and it welcomes the opportunity to contribute to the work of the inquiry. We've made written submissions, and we don't repeat those. We recognise the careful and thoughtful engagement that we heard this morning from Counsel to the Inquiry about suggestions made in ours and various other submissions. And we note what's said about key workers and the focus on lessons to be learned, including action on evictions. We particularly welcome the commitment to hearing the voices of those who are often overlooked or hard to access, and Shelter's keen to engage in how to make this effective, especially for those who've experienced homelessness. Rather than repeat our written submissions, what we want to do is stress two themes. Firstly, the centrality of housing issues to this model and the need to understand, we say, the extent of housing vulnerability and inequality before the pandemic started. This, we suggest, needs to be a broad inquiry, not only to focus on specific areas such as temporary accommodation, important though that is. The second point is about access to housing services, and particularly the Everyone In initiative. On the first point, Shelter believes that access to housing and housing quality played a key role in how the pandemic and lockdown impacted. The injunction in March 2020 that you must stay at home meant very different things depending on what home, if any, you had. That's in background where in the autumn of 2019, over 4,000 people were estimated to have no home at all and to be sleeping rough. A far larger proportion, far larger number, were in temporary accommodation as homeless persons. By December 2020, these numbered more than 250,000. And as we set out in our submissions, 17% of those were in bed and breakfast and hostels. The multiple adverse effects on their well-being were recorded in a contemporary report by Shelter in that year. But beyond this, there's a wider and chronic problem of poor housing conditions. In 2020, 3.5 million homes didn't meet the Decent Homes standard, and 941,000 had serious damp, and often many problems in housing overlap. In addition to that, according to the 2021 census, some 1.1 million households in England and Wales were overcrowded. Many homes had no private plot or outdoor space for use by the occupier. And all of this is compounded by unaffordable rents and inadequate help for those struggling to pay, which reduces housing choice and means that accommodation, when it is found, is often precarious. Now, against that background, we of course understand that the inquiry isn't charged with making recommendations about the general state of housing in the UK or what can be done to remedy it. But it does need, we suggest, to be fully apprised of the pre-existing prevalence of housing disadvantage and how that was liable to compromise occupiers' resilience and their ability to cope. The need to address that is all the more pressing because housing disadvantage of this kind is more likely or more severe for those who already suffer discrimination or who are particularly vulnerable. We've dealt with that in our written submissions, and it's something the inquiry has rightly stressed as a priority. Other submissions speak powerfully to this, and it's critical the inquiry gives full attention to it. But it should do so against the wider background of low quality and insecure housing, where this often overlaps with other factors such as low income. This, we say, is crucial to understanding how the pandemic affected the population generally, and also necessary to model the effects of a similar emergency in the future and identify what steps are necessary to avoid it. There's a general correlation between ill health and poor housing, and the issues here include vulnerability to COVID infection and the ability to keep safe and take measures to avoid infection, such as ventilation, distancing, and keeping clean. and also the fact that measures restricting movement bear more harshly on the well-being of those in overcrowded and poor housing, in addition, potentially exposing them to other health risks quite apart from COVID. And mitigations, thirdly, available to others don't apply. There's often going to be no space to take advantage of something like working from home, and of course less ability to move or go and stay with others. And it's that last point that leads on to our second general theme, which is access to housing services and everyone in. During the pandemic, numbers in temporary accommodation appear to have increased, and the inquiry should, we consider how effectively people were able to obtain housing and homelessness services, and the quality and type of accommodation they were able to secure through that route, and how it affected them. And we're pleased to note that this is specifically under consideration and is a topic to be included in the round table headings. The second point we make, and it's linked to this, is about a specific initiative, Everyone In, under which local authorities were asked to provide accommodation for all who were at risk of street homelessness. There are, as we've said in our written submissions, a number of positive lessons to be learned from this, and we are happy to be able to work with the inquiry in identifying those. But the problem also suffered from a lack of clarity and consistency, with too many people being turned away for a variety of reasons, and support was sometimes difficult to access. A particular problem arose for those who were ineligible for housing and most other assistance because of their immigration status. It would have been possible to alter this in perhaps the same way that there were easements for other statutory duties, but that wasn't done, and nor was there any clear guidance. Now, there may be a number of ways to address this in a future similar pandemic, and shelter would favour a specific emergency duty. But what happened was that the system was insufficiently agile when faced with a clash between a measure imposed to one purpose, immigration control and limiting access to state help, and the demands of public safety. We understand what's been said about the inquiry not trespassing into decision-making in this module, but we don't understand an inquiry of this kind to fall on the wrong side of the line. So in conclusion, those are two issues that we've identified. We've identified a number of others in our written submissions, and by focusing on two, we don't intend to sideline the other points. But we do, of course, recognise, though, that the inquiry is going to have to be proportionate and selective in what it addresses, given a module of this width. But even with that, we agree with other core participants that a 3-week hearing may be insufficient to deal with all the many issues that arise, and we support the suggestion that should be kept under review. Those are our submissions.
Thank you very much indeed, Mr. Westgate, especially for focusing on the main issues that you wish to highlight. Thank you. But I will take into account, obviously, all the other matters you raise in your written submissions. Right, Ms. Munro.
Good afternoon, my lady. Can you hear me and see me?
I can. You've changed horses, Miss Munro.
I'm wearing a different hat today in a different location. Good afternoon, my lady. Today I make oral submissions on behalf of the Justice Sector Coalition. Herein I'll refer to simply as JSC, who I represent along with Ms. Sergis and Ms. Twite, instructed by Joseph Latimer of Public Interest Law Centre. JSC brings together 12 groups. They are listed on the heading of our submission, so I won't read them all out now. But they encompass charities and legal professional bodies, legal aid groups, law centres, who are representative of the whole of the UK. JSC's evidence will provide the inquiry, we hope, with insight into the operation of the legal system during the pandemic across multiple areas of law affecting the vulnerable communities outlined in the inquiry's equality statement. When speaking of the justice system, we say it is important not to conflate justice system and places of detention, for example. For JSC, the justice system includes the obvious, civil, family and criminal courts, but also advice services, ability of our members to enter mental health establishments, police stations, interviews rooms and prisons. My lady, I'm grateful that you've read and are fully aware of our written submissions. I will not address all matters in that document due to the time available, but we do not resolve from any of the important points that we raised there. I do propose simply to highlight in short form 5 points: access to justice, the roundtables, data and stats, Rule 9 and disclosure. All of those in light of Miss Blackwell's very helpful submissions this morning. But before that, just by way of a brief introduction, my lady, the hallmark of a properly functioning society is how it treats its most vulnerable citizens. And in terms of the justice systems, they are illustrative of that fact in many instances, because it is the most vulnerable people within our society who often find themselves at the interface of the civil, family, criminal courts and tribunals. We heard in Module 1 in particular about the state of preparedness and planning of the healthcare systems across the 4 nations, and the question of resilience or otherwise of those systems was brought starkly into focus. We say an analogy can be drawn with the justice systems. Like health, the justice systems are cornerstones of our society. They employ tens of thousands of individuals, professionals from a variety of skills and seniority. These professionals, by dint of their employment, come into direct and close contact with members of the public, often when they are at their lowest, weakest, and most in need of help. In a very real and obvious sense, these are frontline key workers. And like health, the justice system needed to be strong and resilient at the time the pandemic broke. It is important, we say, to contextualise the justice systems at the start of the pandemic. Like health, justice systems faced increasing difficulties and challenges to sustain themselves and properly meet the demands of the public and society to have an effective, fair, open and transparent, accessible justice systems. That is important to understand in order to grasp what happened to them and what happened to those who tried to access and use them. It is their lived experiences that highlight and perhaps best illustrate the problems and difficulties that were faced. We've also seen, my lady, throughout the modules in this inquiry, the theme of discrimination and inequalities and how the pandemic exacerbated existing societal inequalities, particularly in terms of class and structural racism. It will come as no surprise to your ladyship that we also find those patterns when one dissects what was going on in the justice systems at the time of and during the pandemic. So 1, access to justice. Delays in the system led to vulnerable people failing to access justice in a timely manner. Without full and proper access to justice, there is no fairness or effective participation. Everything flows from access. For many of those most vulnerable people in society, the pandemic directly and severely impeded their ability to access such justice. The pandemic and the ensuing lockdowns and social restrictions had an immediate and profound impact on those systems, causing postponements, cancellations, delays in applications, processes, hearings and judgments. This had a direct bearing on the service users themselves, who were unable to access justice when, where and how it was required. It is often said that justice delayed is justice denied. And in the family and criminal courts, certainly, even before the pandemic, they already faced backlogs and delays and lengthy waiting times. The pandemic exacerbated and increased that. Taking crime as an example, my lady, custody time limits were routinely extended, leaving remand defendants and children, though that was changed following legal challenge in relation to children, languishing for extended periods in custody awaiting trial. It also meant that witnesses, including those who were victims of crime, were waiting longer to give evidence. The ramifications were particularly starkly observed in the family courts. Delay and adjourning cases involving domestic abuse, child protection, serious fact-finding and welfare hearings in care proceedings left vulnerable children and families in limbo. Care proceedings placed the welfare of the child at the very centre, yet these were often the very proceedings most impacted. Children and families already facing uncertain futures had that uncertainty increased due to the delays and in turn negatively impacted upon their welfare and stability. Family justice saw a surge in cases post-lockdown, with the child protection referrals increasing rapidly after schools reopened, and concerns about hidden harms to children coming to light. More research, we say, and data analysis is required in this area in order to have a fuller, clearer picture. Applications for non-molestation orders and occupation orders also rose significantly. Mental health, which of course is a central theme for this module, mental health concerns amongst parents became a leading cause of child protection referrals. Digital exclusion and data poverty. In many respects, when the pandemic struck, the move to remote hearings was seen as heralding innovative and speedy remedies to the delays in the justice system. But in fact, digital exclusion and data poverty sadly were not properly considered in the planning. Remote hearings were often not remotely fair. By way of examples, poorer families and excluded communities found it more difficult to access the relevant technology due to not having sufficient phone credits, access to smartphones or computers, or indeed lacking in understanding or capacity to use them. One practitioner described how in a family proceedings, where there were a very difficult family dynamics, one party, the father, could only participate by using his phone from his car, whilst other parties connected to Skype for Business from the family home. He was also unable to communicate and give instructions to his lawyer. Witnesses sometimes had to give evidence remotely from their own homes, where they could not access any emotional or psychological support. Again, a practitioner gave us a very graphic example of a case involving sealing of care for a child and whether or not they should be ventilated. Counsel for the parents had to contact them individually because they were in different locations and tell them the tragic news of their son's situation. The mother, inevitably distressed, was at home with other children who overheard what was going on, leading to one of the children tearfully pleading with the mother's barrister to ensure he could do all he can to save his brother's life. Some practitioners have reported that judges were not always amenable to allowing them time to take instructions mid-hearing for fear that pausing the link may potentially lose the link. And even where telephones and computers could be accessed, the platforms were not tried and tested. Telephone facilities often failed, especially in certain secure psychiatric hospitals and prison environments, where mobile phones were not allowed. And those who needed to rely on these had to rely on video link facilities provided by the institutions. These were often overwhelmed and worked intermittently. In certain housing matters, we have reports of the lack of access to technology, leading in some cases to hearings happening without clients being present. Legal firms were sometimes asked to host clients and occasionally witnesses in their own offices for virtual hearing, thus transforming them into mini courtrooms, a solution to the difficulties faced by the courts, but without any support or risk assessment to those firms and lawyers. Again, examples from the family court, my lady, practitioners have reported judges bypassing legal reps and speaking directly to parents on remote hearings on matters of importance, such as their views on a particular order, but without that parent having recourse to a private consultation with their lawyer, without them having given instructions, and importantly, without them having received legal advice. Understandably, lawyers saw this as highly disadvantageous to their clients. In other instances, judges heard cases on submissions only, without oral testimony from the usual roster of witnesses such as social workers and parents due to difficulties in hearing witnesses remotely. A tier down from remote hearings were those conducted via telephone alone, which produced further problems and, we say, unfairness, both in terms of the process and the outcomes. Mental health was perhaps a very stark example of the difficulties that both practitioners and, importantly, their clients faced. Practitioners noticed that it was always very difficult gaining trust and rapport with new clients over the telephone, but particularly so in the setting of mental health tribunals. When MHRTs were conducted over telephone facilities, this did impact upon the effective participation for inpatients due to their inability to use technology or other communication issues. It also, on occasions, fueled their own mental health or paranoia about how such tribunals were being conducted. This was also particularly difficult for those using interpreters. And there were genuine concern amongst practitioners that as a result, many people did not exercise their right to legal representation because they felt unable to do so without a face-to-face interaction. My lady, those are just a few of the examples that we could give, and perhaps chimes with this point about impact witnesses and how they have given the inquiry thus far some of the most important, visceral and memorable evidence that has fed into reports that have already been written and will be written in future. 2, roundtables. I can say, pausing here, that we are grateful and welcome Ms Blackwell's discussions with the advocates this morning at very short notice. Ms Blackwell and King's Counsel and her team were able to discuss with us some of the matters arising. And going forward, we certainly are confident that this collaborative approach of working together will continue. We are heartened by what has been said in terms of fleshing out some of the skeleton of what the roundtables will entail. These are important because they potentially are discussions that could provide highly relevant, useful information and material to assist your ladyship and the inquiry in terms of fact-finding and determining what happened in the justice system during the pandemic. As importantly, these discussions may assist going forward in terms of how we plan better and prepare for the future and the next pandemic. We are concerned that no opportunities are lost. With that in mind, I echo what has already been said, in particular the submissions made on behalf of the group by Ms Davis, King's Counsel. The issues should not be considered in silo or isolation. What happened in our civil, criminal and family courts did not operate independently of what happened elsewhere, and the lived experience of other groups. They intersect, and it is important that the justice sector roundtables do not become mere echo chambers. And to that end, we say that the process would benefit rather than from one roundtable, but from a series of roundtables, targeted and focused because of the sheer size of issues under consideration. We appreciate the indication that the roundtables will be moderated and minuted, and we note that non-CPs will be invited to take part, although the practicalities of that is obviously something that needs to be further considered. We understand there will be reports and they will form part of the evidence for this module. The reports, we say, should be made public and obviously inform the inquiry's decision-making process. 3, stats and data. Data, or the lack thereof, has quite rightly been a running theme in this inquiry. We have done our own minor research and unearthed some data analysis in respect of the Met Police, employment tribunals and the family courts. Taking the police data, for example, whilst police work in areas such as seizing drugs did not significantly change, the ability of the magistrates' courts and the Crown courts to deal with it did. The mental health tribunals and the social security and child support and immigration tribunals all showed a significant reduction, though they started to climb quickly again thereafter. This limited work that we've been able to in the time underpins our submission that the inquiry would benefit from instructing an expert who would collate and analyse the available data in order to form a clearer view.
I'm sorry to interrupt. I'm afraid I'm going to have to ask you to to bring your submissions to a close?
I will, my lady. The only other matter then is in relation to the Rule 9. We've got on our paragraph 21, we set out 5 named individuals and organisations. We would also request that Rule 9 approach be made to the National Appropriate Adults Network, which is an organisation that was particularly involved in remote representation for vulnerable people at police stations.
Thank you very much indeed, Ms. Munro. I'm sorry I had to interrupt.
Not at all.
Right, I think Mr. O'Carley, have I pronounced it correctly?
O'Cally, my lady, can you see me and hear me?
I can now. I can do both.
I'm very grateful. I appear for the Prison and Immigration Detention Advisory Group alongside Paul Clark, instructed by Joseph Latimer of the Public Interest Law Centre. It's a long-established legal principle that those incarcerated at the hands of the state are in a singularly vulnerable position, and that as a result the state has a duty to protect them. This module will be the first to consider the respects in which, during the COVID-19 pandemic, the British state either met that duty or failed to meet it. As a body composed of leading national charities representing the interests of those detained both in the criminal justice system and pursuant to immigration detention powers, the Prison and Immigration Detention Advisory Group, or PIDAG, is very grateful to have been designated a core participant in this module. In these short submissions, I propose to address the charities briefly. I want to say a little about decision making, roundtable events, the systematic evidence review, and then some matters arising from what the other CPs have said this morning. We commend our written submissions to my lady, and we don't propose to repeat them. PIDAG would particularly like to emphasise the list of potentially important issues that we set out at paragraph 14 of that document. By way of a very short introduction, PIDAG is composed of 4 charities. First, the Howard League for Penal Reform is the world's oldest prison charity. It engages in a broad range of activities which encompass direct contact with persons who are detained in prison, including those who are especially vulnerable in that category, such as children, and policy and campaigning work. During the pandemic, the Howard League provided support to prisoners, in particular children and young people, as the charity runs the only dedicated legal advice line for children and young people in custody aged 21 and under in England and Wales. Bail for Immigration Detainees, or BID, is a charity devoted to securing access to justice for people in immigration detention. BID supports thousands of detainees annually by providing representation in bail applications all across the UK, as well as free legal advice, both in person and by telephone. BID is one of only a handful of organisations that works across the country and across the entirety of the detention estate. BID also conducts field research and uses case sample analyses of its casework as the basis for extensive publications and gives evidence to government and international human rights bodies. The Prison Reform Trust is a charity that conducts extensive research into the workings of the prison system in order to inform prisoners, prison staff and the wider public, and to encourage public debate on prison conditions and the treatment of prisoners. It also provides advice and assistance to prisoners and their families in the form of written guides and a telephone advice line. PRT publishes extensively, including both detailed research reports on the penal system and short focus briefings. Importantly, during the pandemic, PRT initiated the urgent COVID-19 Actions Prisons project, tracking innovation, valuing experience, or CAPTIVE, through its prisoner policy network, which described and recorded life in prison during the pandemic in prisoners' own voices following hundreds of responses. Medical Justice is a charity that works to uphold the health and associated legal rights of people in immigration detention. Working with clinicians and interpreters, MJ facilitates the provision of independent medical advice and assessment to those detained under immigration powers, as well as conducting research into issues affecting people in immigration detention and producing detailed reports. MJ handles between 500 and 1,000 cases a year and continued its work during the pandemic. The pandemic was a frightening time for all, but there's a particular terror that comes from facing the disaster through a locked door. Some prisoners were kept in their cells for 23.5 hours a day. People were held for longer than necessary and in worse conditions. Whilst many of the dangers that apply to society at large were applicable in prison, there were additional dangers faced by prisoners and immigration detainees that simply did not apply to the general population. People died, for example, because of the limitations placed on the assessment, care and custody and teamwork system, because of changes to the prison regime and for other reasons which were specific to detention as a context. Many of these reasons have persisted long after the pandemic was over. That is a long tail of COVID-19. We're very grateful to Ms Blackwell King's Council's indication that there is room for considering the ongoing impact of the pandemic. The PIDAG charities hope to assist the inquiry in examining the particular consequences of the pandemic on the especially vulnerable cohorts they try to speak for. including the ongoing consequences and that long shadow. In respect of decision making, we fully accept and understand what Ms Blackwell's KC had to say about the fact that there has already been a separate module on decision making. But as far as we're aware, Module 2 did not consider what happened behind the locked doors of detention centres and prisons. To understand what happened in those dark places, there will have to be some consideration of, for example, first, the policy choice not to have a proper early release system. Second, the policy choice to continue to use immigration detention with no time limit as a tool at a time when removals, the supposed purpose of such detention, was literally impossible. PIDAG is anxious that the careful delineation of issues necessary in such a broad inquiry as this is not at the expense of allowing it to understand where impacts and harms arose directly from deliberate policy decisions. Without that analysis, it will not be possible for the inquiry to make the recommendations that will lead to better outcomes in any future pandemic. On roundtable events, I'd like to briefly address the proposals we've had. As set out in our submissions, PIDAG very much welcomes the concept of the roundtable events. However, it remains our position that the category of prisons and other places of detention and those affected by the operation of the justice system is just too broadly drawn. PIDAG is very anxious that both of those topics are examined fully, and in our view, that is likely to mean separate roundtables. In our written submissions, we flagged 3 reasons for adopting that position. First, those imprisoned by the state are in a position that's uniquely separate from the rest of society. Their experiences during the pandemic were vastly different from those of people who had their liberty. In circumstances where this is the module to fully examine those experiences, there is considerable value in having a roundtable dedicated to them. Second, while those who were in detention during the pandemic will inevitably have experienced the justice system in one form or another, there will be many detainees and prisoners for whom the experience of the justice system itself wasn't critical to their experience of the pandemic, for example, because it predated March 2020. Third, the justice system itself is a very broad topic that merits its own roundtable and will require consideration of those issues outside the scope of the experience of most prisoners and detainees, as we've heard very eloquently from Ms Monroe, King's Counsel. There is a real issue in our submission that if those issues are addressed at a roundtable together with issues facing detainees and prisoners, neither set of issues is examined adequately. To those reasons, we would add a fourth. A key purpose of this inquiry is to learn lessons for the next one. Prisoners and immigration detainees are a group that will, by definition, be affected differently and almost certainly more severely than the general public in any future pandemic. It's important that the analysis of the failings and successes of the pandemic in this important metric is not swamped by the many complex issues caused by the pandemic in respect of the justice system more generally. In that context, we endorse the comments of the Justice Sector Coalition in paragraph 12 of their helpful submissions. We have had a useful conversation with Ms Blackwell KC, to which Ms Monroe has already referred this morning, and her team, and we appreciate them taking the time to speak to us. We also appreciate, if I may say, the collegiate approach suggested by that discussion and by her submissions this morning. We've been given to understand that there will be proper moderation and separate breakout rooms now at these round tables, which may facilitate at least some detailed examination of the issues affecting immigration detainees and prisoners. Ms Blackwell KC helpfully indicated that further details of the roundtables will be provided. That detail will be essential. PIDAG sees the roundtables as an enormous opportunity for really effective evidence gathering and is anxious that the opportunity is taken. We would welcome the opportunity to have input into the structures of those roundtables. If, contrary to our submissions, my lady takes the view that it's not appropriate to have separate roundtables for the justice system and for those incarcerated, we would ask that the inquiry keep under review the possibility of having further roundtables if the experience of conducting them shows that this is required. In respect of systematic evidence review, I'd like to deal shortly with that. Again, PIDAG is very supportive of this approach, which will hopefully provide the inquiry with an extremely useful evidence base. The charities wish, however, to flesh out 3 short points flagged by Ms Blackwell KC earlier on. First, the specific context of incarceration means that it is vital that both prisoners and people in immigration detention are among the demographic groups that are identified for consideration. As I've already noted, it's highly likely to be of use in planning for and responding to any future pandemic. Second, the work of each of PIDAG's constituent organisations who've done a vast amount of work on this should be part of any systematic review of the available research. Third, PIDAG considers that it will be particularly important to consider the position of those incarcerated and those subject to extreme limitations on the ability to exercise when assessing the impact of the pandemic on physical activity as well as access to support services. In respect of the comments made by some of the other core participants, and we've had an opportunity to consider them now. We'd wish to adopt the following submissions. First, the submissions from the COVID-19 Bereaved Families for Justice UK and Northern Ireland COVID-19 Bereaved Families for Justice at paragraph 17. That roundtable events should be organised with advice from an expert such as a bereavement counsellor or psychologist and approached in a trauma-focused way which facilitates participation and creates an atmosphere in which the bereaved feel heard. Second, the submission of the disabled people's organisations in paragraph 3.6 that the inquiry must examine the position of disabled people in prison, to which we would add that it must also consider the position of disabled people who are in immigration detention. Third, we endorse the query raised by Mind at paragraph 16, the TUC at paragraph 18, and Shelter and the DA group today in respect of the question of whether 3 weeks will be sufficient time to hear important evidence. This was a concern raised in our own submissions, and one that will apply with greater force if the roundtables don't turn out to be as effective as hoped. Finally, we endorse the request of the DA group at paragraph 14 for confirmation that a list of potential invitees supplied by core participants for roundtable events will be considered. In conclusion, my lady, and to recall something said by Ms. Monroe KC earlier, it was the American author Pearl Buck who wrote that the test of a civilization is the way that it cares for its helpless members. Those incarcerated by the state are, particularly during a national emergency like a pandemic, among its most helpless, most powerless, most vulnerable members. PIDAC looks forward to assisting the inquiry as much as it can in its task of determining whether the United Kingdom passed that test during the pandemic and setting out ways of ensuring that in any future pandemic it does better. And those are our submissions.
Thank you very much indeed, Mr. O'Gully. And just to assure you and previous core participant who mentioned it, everything we do is a trauma-informed approach. So please reassure your clients that we'll bear that very much in mind. Next up, I think, is Miss Moffat. Miss Moffat, there you are.
My lady, I'm here. I appear before you on behalf of the Migrants' Rights Consortium, or MRC, led by Piers Marquis and Aswini Weeraratne KC, who cannot be with us in person today, and instructed by the Public Interest Law Centre. I should say at the outset that the MRC is grateful for the opportunity to assist the work of the inquiry as a core participant in this module. The MRC is made up of a range of organisations, 9 of them, whose specific focuses and activities are diverse, but all of which have experience and expertise in a range of topics relevant to the impact of the pandemic on migrant people. Such topics include medical and healthcare outreach, labour exploitation and precarious employment practices, people without recourse to public funds, the immigration and asylum system, the asylum support system, and undocumented people. My lady, the MRC wishes to address you on 3 matters this afternoon. First, the duration of hearings. Secondly, provisional scope. And thirdly, evidence gathering, in particular, roundtable events and the Rule 9 requests. I can deal with the first very briefly to say that we respectfully echo the request made by a number of other core participants in this module that the duration of the public hearings be kept under review given the breadth and complexity of the 4 topics to be covered. Turning secondly to scope. We acknowledge that the outline of scope for Module 10 remains provisional and that the core issues will be identified as the module progresses and as evidence is obtained. With this in mind, we make the following 3 submissions. First, that the meaning of the most vulnerable should be interpreted broadly to include also those migrant people who fall outside the immigration and asylum system. And indeed, we are grateful to Council to the Inquiry's indication this morning that the undocumented people are not expressly excluded. We welcome this since precariousness that accompanies a lack of immigration status means that undocumented people were particularly vulnerable to the effects of the pandemic. Many of the constituent organisations of the MRC worked with undocumented people during the pandemic and would be able to assist with evidence gathering relating to the impact of COVID-19 on this highly vulnerable group. Secondly, the MRC observes that immigration status creates vulnerability in diverse ways, and the experiences and vulnerabilities of our client base are diverse. However, we also acknowledge that in general terms, migrants, as distinct from citizens, are vulnerable in 2 overarching ways. First, they are excluded, with certain exceptions, from the democratic franchise, and they do not have equal political rights to citizens. And secondly, they're subject to some form of state control over their ability to enter and reside in the United Kingdom, which means in particular a vulnerability to forms of state coercive power, including detention, control over the ability to work or access benefits, and ultimately exclusion and expulsion from the UK. Thirdly, the MRC submits that the impact of the pandemic on migrant people should be a separate question to be investigated under Module 10. We note that a similar submission has been made by the DA group today and in written submissions. Additional to the topics covered by the existing questions as identified by Counsel to the Inquiry, the particular impacts of the pandemic on migrant people are likely to include impacts on those who are undocumented or had no recourse to public funds, those in asylum support accommodation, those in immigration detention, those affected by the closure of borders, and those affected by delays and backlogs in Home Office decision-making. The MRC respectfully requests that these points be taken into account as the core issues are identified and redefined and when other procedural decisions are relating to scope are made. And finally, the third topic on which the MRC wishes to address you, evidence gathering, and in particular, roundtables and Rule 9 requests. Our submission on roundtables is related to our submission on scope, and I should say at the outset that the MRC welcomes the roundtable events, given the importance in Module 10 on focusing on the experience of those affected by the pandemic. However, we consider that the absence of a roundtable to address specifically the impact of the pandemic on migrant people is a material omission. Within the roundtables as currently envisaged, we consider that there are categories of migrant people whose experiences and interests would not be covered or heard. An obvious example of this is simply those affected by the operation of the asylum and immigration system, including those affected by delays and other problems in the processing of applications. The omission of the migrant experience from the roundtables as currently envisaged is striking, we say, particularly given that other groups of people within the provisional outline of scope for the module, which the module identifies as the most vulnerable, will have dedicated roundtable events, such as housing and homelessness, prisons, and those affected by the operation of the justice system. Whilst we acknowledge that the roundtables are not the exclusive or only means of evidence gathering to be used by the inquiry, we suggest that the inquiry would benefit from a roundtable specifically addressing the impact on migrant people to ensure that voices from all sectors from society are included and to give parity in evidence gathering with other groups identified as the most vulnerable. In the absence of a roundtable specifically addressing the impact on migrant people, however, the Consortium would be grateful for further information and clarification as to the alternative means that will be proposed by the inquiry and when such evidence will be gathered. Finally, and relatedly, in respect of Rule 9 requests, the MRC is eager to assist the inquiry through the provision of witness evidence, which we consider is particularly relevant to Module 10's focus on impact. In making decisions on Rule 9 requests, my lady, we ask you to take account of the diversity and number of the MRC's constituent organisations, which we believe is inimical to the provision of witness evidence through a sole statement on behalf of the group as a whole. I close, my lady, by saying that the MRC is committed to supporting the inquiry's important and significant work on Module 10 and to make it as considered, thorough and effective as possible.
Thank you very much indeed, Ms Moffat. And lastly, Ms Peacock.
Thank you, my lady. I hope you can hear me.
I can.
I appear on behalf of the Trades Union Congress, led by Sam Jacobs and instructed by Thompson Solicitors. I need not emphasise to you, my lady, the critical importance of this module to those who I represent and to the over 5 million working people who make up the TUC's 48 affiliated unions. Counsel to the Inquiry referred this morning to the great personal risk faced by many key workers during the pandemic. For many, that risk transpired. Thousands of workers died with COVID-19 and many more continue to suffer lasting physical and mental harms as a result of the virus. Turning first to the scope of the module. We welcome the inclusion in the provisional outline of scope of a range of sectors and roles, and we are grateful to Council to the Inquiry for our indication this morning that the list of key worker groups is not exhaustive. However, we remain concerned that the key worker groups identified in the provisional outline of scope focus upon the roles which were public-facing. And in respect of sales and retail workers, it is specifically identified that those who were public-facing are those whose experiences will be considered. The implication potentially being that those who were not public-facing would not be considered. If the intention is to focus on public-facing workers, we consider that this would be an unhelpful approach, as it would be to overlook some of the most vulnerable and worse impacted groups of key workers. By way of example, I intend to address in these submissions manufacturing workers, construction workers, and warehousing workers. In the first preliminary hearing in Module 7, I addressed you, my lady, on the risk faced by manufacturing workers due to a lack of sick pay. I referred to the outbreak at a Bakkavor food processing factory, which was followed by 100 workers testing positive for COVID and the deaths of 2 factory workers. Similarly, a series of outbreaks in the Leicester garment factories was such a cause for concern that Public Health England sent a team of officials to Leicester to investigate the cause in June 2020. As has been heard in other modules, data from the Office of National Statistics shows that process, plant and machine operatives were among the worst affected in terms of both infection and mortality. Indeed, in our written opening submissions in Module 1, if we cast our minds back, we highlighted that the rate of deaths of COVID-19 for factory operatives was over 6 times higher than those in professional occupations. If you'll oblige me, my lady, I intend to read just 4 short extracts from the survey responses received by the TUC. A production operative working on a conveyor belt in a food processing factory in London said, "For a long time, even after the pandemic had started, no one was wearing any mouth protection, and never was I able to distance myself from the person next to me further than 2 feet. Mostly my social distancing was limited to 1 foot." A bakery operative at a factory in the West Midlands recounted that our employers expected us to carry on as usual. Eventually, social distancing was put in place, but we were refused masks. We lost a very close colleague during the pandemic, and only then did we feel that people were taking this seriously. I was scared, and no one at work seemed to care. A lead technician in the Northwest told the TUC, "I didn't feel safe. There was pressure placed on the production staff to attend work regardless. I was clinically vulnerable and asked for a mask, but initially my request was ignored. They were more interested in production than well-being." And finally, my lady, a bakery operative in the southeast said, "I didn't feel safe at all. They put some measures in place, but we could not social distance, and we got different agency workers in every night. I was sharing a workstation computer with up to 10 different people each shift." Turning to construction workers, the prevalence of insecure work and low pay in this sector led to high levels of presenteeism. A survey of construction workers in 2022 reported that for 59% of respondents, financial pressures meant that they would continue to go to work even if they tested positive for COVID-19. ONS data from 2020 found that for men, the highest rate of death involving COVID-19 was in elementary workers, which includes construction workers, refuse workers, and cleaners. In April 2020, ONS reported that there had already been 87 COVID-19 related deaths of workers in the skilled construction and building trades category, and 90 deaths among workers in the skilled metal, electrical, and electronic trades. Turning finally then to warehouse workers, those in warehouses faced similarly elevated risks. In April 2020, GMB issued a statement on behalf of their members employed by Amazon. They explained that workers are being made to clock in and out at the same time as hundreds of other workers, while packed company buses ferry workers back and forth. GMB members report being made to pack and pick items in cramped aisles with no hand sanitizer, gloves, or masks available. Similarly, an outbreak occurred in May 2020 at an ASOS warehouse which employs 4,000 workers. A survey by GMB of 500 workers at the factory found that 98% felt unsafe at work due to COVID-19. Workers reported no social distancing measures, a complicated clocking in system which meant large numbers of people gathered at the same time in a small area, and a lack of staggered work breaks. A recent study, cited in our written submissions at paragraph 8, reported an analysis of COVID-19 workplace outbreaks across England between May and October 2020 found that warehousing workplaces, including storage and distribution centres, had some of the highest outbreak rates, second only to manufacturers and packers of food. In the manufacturing, construction and warehousing sectors, workers did not typically have direct contact with the public, but they faced grave risks and lasting impacts of the pandemic nonetheless. Indeed, it appears likely that some of the increased risk was precisely because these workers are not visible and ordinarily their work takes place behind closed doors with little public scrutiny of their working conditions. A higher degree of physical proximity to others has, in numerous sources of evidence before this inquiry, been linked to greater risk from COVID-19. However, it is not the case that that proximity needs to be to members of the public. There is clear risk posed from proximity to colleagues. Indeed, we heard expert evidence from Dr. Warren in Module 3 that a significant part of the risk for healthcare workers was worker-to-worker transmission, rather than transmission directly from patients. For those reasons, we say that this module ought not to take as its focus only those key workers who were public-facing, but should analyse the situation for those who had to attend workplaces in person and could not work from home. Turning to this module's approach to recommendations, we are grateful to Counsel to the Inquiry for her indication this morning, in response to our written submissions, that this module will be forward-looking and will seek to identify strengths and resilience that mitigated harm to ensure that positive lessons from the pandemic are not overlooked. We welcome that approach. We note, and this is perhaps simply a point of emphasis, my lady, that there may be lessons to learn from the negative impacts of the pandemic. We must consider carefully the weaknesses and the vulnerabilities which the pandemic laid bare. Recommendations flowing from this module should be responsive to the harm suffered during the pandemic, which may require this inquiry to look beyond what occurred during the pandemic, retrospectively, but to consider what ought to happen in the next pandemic. In respect of expert evidence, Counsel to the Inquiry referred to our request that this module obtain expert evidence which considers the impact of outsourced and agency work upon workers and the role this may have played in terms of the inequality of impact. We are grateful to Ms. Blackwell-Casey for her indication that this matter will remain under review. We say only that we consider that this is a gap in the evidence received in previous modules. It's an area where expert evidence, we say, would be particularly enlightening, given the vulnerability of workers in this category, who are often excluded from workplace statistics and may be slow to come forward with their experiences due to the insecurity of their positions. We heard, for example, from an outsourced cleaner in Module 3 who gave evidence only after their identity was concealed. There will be many more, we suspect, who were too fearful to give evidence and about whom expert evidence would be critical. My lady, I now turn to Rule 9 requests for information. Mr. Jacob addressed you on behalf of the TUC during the recent preliminary hearing in Module 6 on the need for the inquiry to obtain first-hand witness evidence from workers who were on the ground in the care sector during the pandemic. We consider that those submissions apply equally in respect of this module and the key workers it focuses upon. The need for impact evidence from a range of witnesses has been raised in writing and orally today by a number of core participants. We support those submissions. We consider that there must be space in this module for the human stories we heard in Module 3. We say that there is no substitute for hearing from workers directly and inside this inquiry room. We stand ready to assist in identifying appropriate witnesses across a range of sectors. Finally, I turn to timetabling. We make the submission in writing, and it has been addressed and endorsed by a number of other core participants. It's not a submission we make lightly, nor is it one we've made in every module. The final module, we say, should be a meaningful, substantive analysis of the impact upon society and what we should learn in advance of a future pandemic to avoid those impacts occurring again. It must, we say, avoid becoming a whistle-stop tour of harm suffered during the pandemic. Thank you, my lady. Those are the submissions of the TUC.
Thank you very much indeed, Ms Peacock. Extremely grateful as ever. I think, Ms Blackwell, that completes the submissions, unless there's anything you wish to say by way of reply.
No, thank you, my lady. There are no matters in relation to which we wish to respond today, save and except to say that we have been listening carefully to the oral submissions made on behalf of all COL participants, and we will take those away and continue to listen throughout the course of this module. Thank you.
Thank you very much indeed. And obviously I'll discuss with you anything that has occurred to me during the course of the submissions. They were all extremely helpful, and as I indicated earlier, I intend to take into account all the written submissions, as well as always the very constructive submissions that I've heard during the course of today. I'm very grateful to everybody, and that concludes today's hearing.
Thank you, my lady. Good afternoon.
Thank you.